You were previously convicted of theft of 1984, 1985, of 1989, 1991.
This isn't a first-time mistake. This is a lifetime pattern. We're talking decades of theft, repeated chances, and still the same outcome. The court is already spotting red flags before the defendant even speaks. Offers on the table, years at stake, and she's about to gamble everything. The real question? Is this confidence or complete denial?
Looking at the indictment on this one, are any of these prior thefts actual third degrees or higher, or are they all enhanced because they're state jail felony with prior thefts? Because if they are, I don't think we get to the second degree.
You don't?
I don't. I feel like we've talked about that. I think you can't enhance and then enhance again. Unfortunately, I don't necessarily agree with that law.
I think it is, they have to have another felony other than.
It's my understanding that if it's a misdemeanor theft that's enhanced to a state jail, then it can't later be used to enhance another misdemeanor
Unless it's a
enhanced.
different felony.
It has to be either a regular felony of any type. It can be a theft, but it has to be a regular felony theft,
Right.
or it has to be a regular felony of some other type, which is unfortunate in my
So in
opinion.
my notes, Judge, just if I may, and I would be happy to go back through and map all of these priors out. It looks like when I originally reviewed it, I made note to myself that she had at least two misdemeanor thefts that were enhanced to state jail with sequential regular felonies.
Okay.
But if the indictment doesn't reflect that.
Well,
maybe
I don't
that-
know if it does, because the indictment doesn't list them like that. It just says theft. It doesn't have the degree. So
Right.
I would need, if we're going to go through the indictment, if you can hold it while you check which ones might be real
Yes.
felonies.
Yes, and in light of that, Judge, since she's going to reject, I think it's very clear that it's a third degree. My offer was a 5-year cap, so that would be within a
But I don't
third
know
or
if-
second.
I don't know
But
if
I
it
know we
is.
need to admonish her.
I don't know if it can even be a
A third?
third unless, let's
I'll
look
check.
at it. I feel like, I don't know, I feel like we've done this and then I forget again and then I go back through it, but, okay, I'll hold it. Yeah, double check if it can be either.
Okay. It might take me a minute.
Yeah, because I think if they're all enhanced, then it doesn't matter if it's a second or a third or whatever it is, unless they're real felonies, I think. But y'all double check me, please. And if you have the real felonies, that makes it easy instead of the enhanced ones. Okay, just go back with the bailiff for a minute, ma'am. Let's see. Good morning, ma'am. Are you Veronica Randall?
Yes.
And Ms. Randall, in cause number 25, GCCR 0246, you're charged with the state jail felony offense of theft of property with previous convictions. That's from November 21st of 2024. Your indictment alleges you were previously convicted of theft April 4th of 1984, April 11th of 1985, April 10th of 1989, November 12th of 1991, October 10th of 1994, May 6th of 1999, April 17th of 2008, August 24th of 2015, April 29th of 2016, November 28th of 2016, and then February 11th of 2019. And what that means is that
There's
Judge, you
Also,
allowed us a little bit of time last week. when we had
Yes.
This issue, I feel like just to be on the safe side, we have marked third degree. I've gone through the priors. There's a lot of underlying misdemeanor priors that some of them, to be quite candid with the court, will be difficult to prove up due to the age of the prints.
Okay.
So I think it's probably safe to say it's at least a third, if not a second. Based on this offer, we would move to proceed on the third at this time. If this is rejected and we do get on the trial docket and I have a little bit more time for Mr. Robinson to look at those prints and we make a determination.
And there are other way
I will
other
give
than
notice.
prints. I mean,
Correct.
those can be proved up even if there's no prints, as long as there's,
I will give a appropriate notice was
Okay.
placed on the trial.
So, Ms. Randall, what that means, as you heard, is at least for you would be facing punishment of a third-degree felony if you go to trial and you're found guilty, which is between 2 years and a 10-year punishment, with the possibility of it being a second-degree felony, and that would be between 2 years and up to 20 years. Do you understand? And then in cause number 25 DCCR 0247, you're also charged with theft of property with previous convictions. That's from November 16th of 2024. Same prior offenses are alleged in that indictment. Same thing with regard to punishment. Do you understand? And then in each of those cases, I have here on the computer plea bargain rejections that you've signed with Mr. Parker that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for 4-year terms in the institutional division of the Texas Department of Corrections. I want to make sure you understand what your possible consequences are and what your options are, and do you understand all of that? And do you want to reject those offers and have your cases set for trial? And Ms. Malfino, is there any reason to believe that these offers would change?
No.
I want to make sure you understand, Ms. Randall, that after today, I will not accept these plea agreements. Once your case goes on the trial docket, it's going to be tried in front of a jury, or it would be a plea to something other than this, but not less. Do you understand? Okay, and I will get your case set on the trial docket. Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? Mr. Parker, you're released. Ms. Randall, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. Okay?
Judge, just if I may, for the record, in addition to providing notice of whatever enhancements I can, I will also most likely file a motion staffing sentences.
So I want to make sure you also understand, because these offense dates were different dates, that if you're found guilty in each of these cases, the state can request that any punishment you receive I run consecutively, which means stacked on top of each other. I'm not telling you I'll do that, but that could be something that could happen in your cases. Do you understand? And do you still want to move forward with trial in both cases? All right, we'll get it set. You can go back with the bailiff. Good morning. Are you Veronica Randall?
It's Gianna.
And Ms. Randall was previously in court in cause numbers 25 DCCR 0246 and 0247. Entered pleas of guilty to theft of property with previous convictions, a state jail felony. Also entered pleas of true to prior convictions, which enhanced this to I believe, second-degree felony for punishment purposes. The agreement was for a cap of 6 years in prison. I've received and reviewed that pre-sentence report. Have you all both had an opportunity to review that report?
Yeah, Sean.
Yes, sir.
Are there any additions or corrections to the report?
All good? What you read? All accurate? No, no additions.
Judge, I don't have any additions or corrections. I would just state if it's the appropriate time for the court. When I look at it, I have some empathy for Ms. Randall based on the comments that she made. But how much can we take her out of her word with her criminal history? The court will recall you previously rejected 4 years in this case. I'll defer to whatever you think appropriate. Yeah, Judge.
I also have taken judicial notice of the jail incident reports. You both should have copies of those. Have you both had an opportunity to review those as well?
Yes, sir.
Yeah, Sean.
All right, Mr. Vasquez, you may proceed with argument.
Gianna, I know Ms. Randall's had probation a couple of times in the past, and it didn't work out for her. But I'm arguing for anything that does not involve incarceration. Ask the court to just grant her probation with every condition, and that the court thinks best would help her to quit offending. And in lieu of that, I mean, in the alternative, you're not asked for something less than the 6 years. If she's going to.
Anything else, Ms. Mulvaney?
Judge, I don't have any additional comments. I would just state that our agreement initially was to dismiss the new case because she already has the sequence felony priors. That would enhance anything further, but if the court disagrees with that, we can visit about it after the sentence.
So, Ms. Randall, I made some notations on this pre-sentence report, some issues and maybe some mental health issues that have contributed some issues in the past. However, there's nothing in here that makes me believe that any condition you may have is what requires or makes you go out and do what you've done. Literally since 1981. Your first theft that I have here was from an arrest from 1981. Then I have one after another misdemeanor thefts through 2018. Then we've got, starting in 1986, a robbery and a theft. And then we've got 13 felonies since then. These are your 14th, 15th, and I guess 16th felonies. At some point, you got to figure it out. There's opportunities when you are not incarcerated and not on probation to get the help that you need if that's what you think is the problem. I think the problem is you just like to go steal or rob, because I mean, we've got robbery, aggravated robbery, another robbery. Anyway, so at this time, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you also entered your pleas of true to those prior convictions freely and voluntarily. In cause number 25 DCCR 0246, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find the other previous convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0247, I'm also going to find sufficient evidence to find you guilty, find those prior convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I will sign a dismissal in clause number 25 DCCR 1686 as part of this agreement. I'm handing you the trial court certifications in each of your cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez. Right, ma'am, you can go back with the bailiff.
Thank you.
6 years. Not the maximum, but far from mercy. The judge weighed the history, the rejected deal, and the repeated offenses, and made it clear, choices have consequences. This wasn't about one case, it was about a lifetime of them. So what do you think? Was this fair sentencing, or did she throw away her last chance? Comment below, hit like, and subscribe for more real courtroom breakdowns.